Welcome back. While the Madlanga Commission continues to hear testimony from the KZN top cop who lifted the lid on Vusimuzi Cat Matlala's alleged links with the police minister, the Alexandra Magistrate's Court has denied the multiple attempted murder accused businessman bail. The court found that he failed to prove he would not be a flight risk if released on bail. Newzroom Africa's Mnisi is live for us from outside court. Linda, very good afternoon to you. So, Vusimuzi Cat Matlala has been denied bail, and Magistrate Prince Lou citing a number of issues, saying that his alleged possession of an Eswatini passport, as well as his ability to communicate with the outside world while in custody.
Absolutely, Katleho. Those are some of the issues that the magistrate highlighted. And you recall, these are issues that were brought during the bail application and were argued by both parties. And by both parties, I mean the state as well as the defense. So Vusimuzi Cat Matlala in this matter was the applicant. And you recall that one of the reasons that the state, brought in opposing bail was the issue around his Eswatini ID card, saying that at some point he had asked his wife to take a picture or send him a picture of that Eswatini ID card in which he is named Vusimuzi Dube, and they're saying that at this particular moment there's no indication that he's that particular person, and it also indicates that he may have traveled outside and went to Eswatini. It's among some of the issues that they raised, including the fact that they said he had other economic interests, for example in Mauritius, saying he had a private jet as well as abodes in Mauritius. But he said, well, look, I only have a trust account. I've established a trust account in Mauritius with the intention of doing business in that particular country. He says that that particular picture that was seen in his cell phone records, he believes was planted by the police in order, of course, to use in proceedings like these. And the court saying that there is evidentiary material in the form of the letters from Home Affairs that indicate that he may have traveled outside of Eswatini, and at this point it points to the fact that he left South Africa going to Eswatini, but there isn't really any reliable record that points to the fact that he returned to the country, and therefore finding that he did not prove or discharge the onus that was placed on him to prove that if he is released on bail, he will stand trial. Let's take a listen to what the magistrate had to say.
In weighing these competing versions, the court is not satisfied that the applicant discharged the onus of demonstrating that he does not pose a flight risk. On the contrary, the evidence of the foreign financial interest, the allegations of possession of an Eswatini identity document, the unresolved border movement anomalies, and his proven ability to access communication devices while in custody collectively indicates that the applicant has both the means and the potential opportunity to evade trial.
Vusimuzi Dlamini Katleho is the correct word that was in that particular Eswatini ID and not Dube, as I previously indicated. But it's among the number of reasons that the court gave in denying him bail. You recall, this is a Schedule 6 offense, and which means the onus rests on him to prove that there are exceptional circumstances, and that is the legal test. Discharging exceptional circumstances that would warrant your release on bail. In essence, you must tell the court why it is that if you are not released on bail, you will suffer prejudice. And he says, and rather she says, that among some of the things that she had to consider was whether or not there would be an interference with the witnesses, or if, of course, the public would be in danger. And she highlights that he was found with a phone while in custody, and in the phone, the analysis revealed that there may have also been communication with a police officer who was saved in his phone as operative, but also on the day that Lieutenant Colonel General Nhlanhla Mkhwanazi made those explosive allegations on July 6th, he seemed to have also communicated with Brown Mokhotsi. You'd recall that Brown Mokhotsi, according to Mkhwanazi, is an alleged associate of now suspended Police Minister Senzo Mchunu. And essentially, the court saying that it proves that he may, interfere with witnesses and that he is, of course, a danger to society. Take a listen to the magistrate denying him bail.
In the bail application brought in terms of Schedule 6 of the Criminal Procedure Act, the onus rests on the applicant to satisfy the court on a balance of probabilities that exceptional circumstances exist which, in the interests of justice, justify his release. Having evaluated the evidence, the court finds the applicant has failed to demonstrate that he does not pose a flight risk. The applicant has failed to dispel the risk of interference with state witnesses and obstruction of justice. The nature and seriousness of the offences demonstrate a clear danger to the safety of the community. The state's case viewed at this stage cannot be described as weak.
Vusimuzi Cat Matlala arriving in court donned in designer wear, but it seems he has nowhere to go. The matter has been postponed to the 7th of October when he returns to court.